Good afternoon. Thanks for joining today's program. My name is Mel Shaw, and it is a privilege to serve as the president of the Iowa State Bar Association and to introduce today's program to you, the topic of which is judicial retention, voting on the back of the ballot. We have with us an esteemed panel today, who includes the Honorable Michael Streit, former member of the Iowa Supreme Court. We have Guy Cook, former president of the Iowa State Bar Association, Rox Laird, who is an emeritus member of the Des Moines Register editorial board. We have Connie Ryan, president of Justice Not Politics, and we have Bob Waterman, former president of the Iowa State Bar Association, who will moderate today's program. I want to let you know that this program has been organized by the independents of the Judiciary Committee, along with the staff of the ISBA, and it's our intent that you receive valuable information so that you're able to better understand what is the judicial retention process and why it is important. With that, I'll turn things over to Bob Waterman.
Thank you, President Mel Shaw. As advertised, the purpose of the webinar is to learn about Iowa's judicial retention elections, what a yes and a no vote mean, including what are they? What's the judicial retention elections? Why does Iowa have them? And what does a yes or no vote mean? Just by way of some background, in this election, one Supreme Court Justice, David May, and 4 appellate judges and 64 district court judges are standing for retention in this year's general election on November 5. The Judicial Performance Evaluation, also known as the plebiscite, if it's still called that, was sent to everybody that's a bar member, and that was 5,614 ISBA members residing in Iowa. And of those 5,600, we had responses from 1,045 bar members who completed the evaluations. At the end of this presentation, which is scheduled for credit of 45 minutes, but we may go over, and if we do, we'll let you know if you're going to get any more credit. But there's a Q&A button on your screen at the top. If you're going to have questions, please submit them. All the panelists will see them. Subject to time, I'll decide whether how many and whether any get answered. Thank you. We're going to start off with past President Guy Cook, who is chair of the independents of the Judiciary Committee. Could you, Guy, please get us started with a brief history lesson on the purpose of Iowa's judicial retention elections and what a yes or no vote means? Thank you.
Sure. Thanks, Bob. Of course, more than a half a century ago, Iowa voters, fed up with direct election of judges and the corruption that had taken place, organized and voted to amend the Iowa Constitution to eliminate the direct election of judges and go to the merit selection process, which created a nominating commission of lay people and lawyers who heard applicants, interviewed them, reviewed their resumes, and then nominated those they found with the most merit to the governor to be appointed to the bench. And then once on the bench, a judge or justice, the first year they stand for retention, and then every 8 years. And the retention election is a non-candidate. There's no one opposing the judge. It's a simple yes or no, should the judge be retained. And of course, people can choose how they wish to vote, but we'll discuss here today, I think, some of the background as to some suggestions as to the impact of a yes and no vote.
Thank you for that background on the retention and the merit selection process. Next, Guy, again, I'd like to ask you, when and why was the ISBA Independence of the Judiciary Committee formed?
Well, I can't give you the exact when it was formed, but I can tell you it's been most active following the 2010 retention election, where 3 justices were voted out as a result of the same-sex Varnum decision, and the Bar Association became more aggressive in trying to educate the public on civics and trying to come to the rescue of judges who might be unfairly attacked. And that committee has been active vigorously ever since then.
Great. And I'm going to stick with you just a couple of more, and then we'll move on to others. There have been a number of recent articles and social media postings written about Justice May, who is one of the only justice standing for retention, and whether he should be retained. You, on behalf of the ISBA committee, have been quoted as saying, quote, "There is no good case to fire Justice David May. The only case made is for perpetuating a cycle of retribution which undermines judicial independence, the bedrock of the rule of law. A vote of no based on one issue unfairly attacks our institution and undermines judicial independence." Could you explain to our attendees what you meant by that quote?
Sure. So, and that it goes to what the purpose of a retention election is. It's not designed to be a referendum on a decision or ruling by a judge. Of course, I would never be so arrogant as to suggest how people should vote, yes or no. It's a personal decision. But the function of the retention election is to allow the public to have input on whether the judge still has the same merit they had when they were appointed by the governor. Are they following their code of conduct that all judges must follow? Have they done something improper or contrary to their oath that would warrant voting no? Of course, here we have an important decision that has a difference of opinion, including on the court, where there were dissents, a very vigorous dissent, well reasoned by Chief Justice Christensen, who I personally happen to agree with, but nevertheless, deciding to vote no on one particular decision has this corrosive effect on the independence of our judiciary, and frankly puts judges looking over their shoulder as to what will happen if I try to do the job as best I see it. And that's not what we want. Fair and impartial judges is what we want. We want the judiciary to be independent. And it's really the only branch of government that should be, as best it can be, not influenced by politics.
Thank you, Guy. Connie Ryan. Now, we've heard about the ISBA's Committee on Judicial Independence. You co-founded and are board president of Justice Not Politics. If you could please explain to our attendees, what is Justice Not Politics? When was it formed, and why was it formed?
Thank you so much. And thank you for allowing me and Justice Not Politics to be part of this really important conversation. Justice Not Politics was formed really after the 2010 election and retention election. We were part of that work, but we didn't become an entity until after 2010. And it was a response to when Bob Vanderplatz stood on the steps of the Supreme Court outside and announced that he was going to go after the three justices that were up for retention in 2010. And truthfully, I made a call to some folks and said, we need to have a response to this and have a different voice out there, a different narrative out there on behalf of the justices. And so, as everyone knows, the justices lost their seats in that retention election, and we decided that we needed to really continue the work of what became Justice Not Politics, and have been doing the work of protecting Iowa's fair and impartial courts ever since then for nearly 14 years. And so it is important that folks understand, as Guy was talking about, the intention of retention elections and the difference between a retention vote and the partisan votes that we are used to as Americans in voting with the legislature, with the governor's seat, with the presidential seats, et cetera, and that retention elections are different.
Thank you very much for that. Could you share with us, how does Justice Not Politics do its messaging? How do you reach out to the public? I know that you can sign up for emails. What else have you been involved in? I know there are newsletters that you publish. What's the medium that you use to get your message out?
We use all of the typical communications, so emails, and yes, folks can sign up for information, social media, of course, all of those kind of tools, press releases, et cetera, when those are warranted. And our message really is around fair and impartial courts. And in a retention election, we say very clearly, as Guy indicated earlier, that every person gets to decide for themselves what that vote is going to look like. And every person has their own criteria of what a retention vote should be. And so we're not here to judge what those votes are. We're not here to tell you how to vote. But we do give some suggested things to think about, questions to think about when you're making a decision on a retention vote from a Supreme Court justice to a district court judge. And so, if I may, I can share some of those questions that we suggest, but you're the moderator, so I'll go with what you want.
Very good, audience. I did not share my questions, but actually that's getting into my next question, which is in the the election ballot. And I'm sure I'm not the only one who's been asked, how am I supposed to vote on this? Because all it says is, shall the following judge be retained in office, yes or no? There's no criteria. The ballot doesn't include anything, just yes or no. In the Justice Not Politics newsletter, most recently, I guess October 13, it does provide criteria for voters for evaluating judges for retention. Could you explain the criteria that you have provided and suggested for areas that the voters can use in determining whether to vote yes or no on a judge or justice? Thank you.
And if I can interrupt here, Connie, when you answer that, I think we've got a question that says, well, in the plebiscite amongst the lawyers, there was 35% that said he should not be retained. How do you accommodate that point of view in your advocacy with your organization and your people?
Yeah, well, let me answer the guidelines that we suggest first. And it really is, again, every person has their own criteria, every person has their own viewpoint. And so we don't want to circumvent that at all. So these are suggested questions to ponder in your heart when you're making a decision for any judge or justice at any level, not just Justice May. We ask ourselves, do the judges or justice standing for retention have a good temperament to serve on the bench? It's critically important, the temperament of a judge or a justice as they are talking with folks and dealing with folks and asking questions and how they're running their courtroom, so to speak. Do they treat people who stand before them equally and with fairness, whether that is a lawyer or whether that is somebody who is coming before the court? Do they treat people fairly and equally? Are they professional in their role? Are they competent and have the knowledge and qualifications to serve? And as Guy was indicating earlier, this is about they were selected because of their merit at the onset, and then retention is part of that. Is have they retained that? Are they competent and have knowledge and qualifications to serve? And do they serve in an ethical manner? Inside the court and outside the court, both are important for a judge or a justice to have the ethics that the position warrants. And so to Justice Streit's question, again, everybody has the right to make a decision on their own how they're going to vote. We know that there's a fair number of folks who vote no in every retention election. It's just something that people do because for whatever reason, they're mad at the government, they're mad at the courts, they're mad, or they just don't think somebody should be on the court forever, whatever their reasoning is. We know there's a good percentage of folks who just vote no anyway. And so whether it's lawyers that are voting in the review, or whether it is voters who are voting in the retention, everybody gets to make that decision for themselves and their experience with the justice or judge in the courts. We would suggest that people ask the questions of themselves before they actually cast a ballot, and then they can go forth and make their own decisions.
Thank you, Connie. And being on your website, I see that to answer these questions, you also suggest that you learn about the judges going to the map of Iowa's district courts, see the list of judges, and then look at the judicial performance review, because that's made public. And that's more information for your readers and your interested parties and voters to gain more information about the judges. Is that right?
Because the review really, and any guy or anyone can speak to this better than me, but the review really takes the experience of lawyers that have been in court with those judges and justices and how they experience them, how they rule, their temperament, all of those questions that we asked. And so we value the review, the judicial review that the Bar Association puts out before each retention, and consider the Bar Association to be a partner in this work of fair and impartial courts. And so we always recommend that folks go and look at the judicial review and take that into account. The attorneys that are serving in those courts and experiencing the judges and justices on their own and in their work. And so that's important information. It's not the only information, but it is important information. And so would always recommend that. And then, as we've said a million times already, at the end of the day, it's the voter's decision. And there can be other factors in their life that they take into consideration. And so that we just continue to recommend that folks think about it holistically, and the relevant questions that would be part of the decision making.
Thank you, Connie. And moving on to other areas of information and access to resources, I'm going to turn to Rox Laird with the Des Moines Register. He's an emeritus member of the Register editorial board. And this is another area, as there are around the state, Cedar Rapids Gazette, Quad City Times, that voters can look to and read what they have to say about the various justices and judges standing for retention. Rox, in addition to, you're a member of the Des Moines Register editorial board. Could you please explain the recent editorial in the Des Moines Register that included the following, and explain how the editorial board landed on this sort of a position for our audience members? What did you take into consideration? And that quote from a recent editorial goes as follows: "A vote to remove Iowa Supreme Court Justice David May from office is a vote to give up on the idea that judges can be different from the partisan operatives in other branches of government." And that specifically was by Lucas Grunmeyer on behalf of the Register editorial board. You explain the process of what the board goes through when it decides what position it's going to take on this sort of an issue, what resources it looks into to arrive at its best judgment on a position it's going to take.
Right. So basically, the Register has been an advocate of preserving Iowa's merit selection process, and we have always, in these elections, have always advised voters to go through the process that Connie's group suggests, and the Bar Association information, and we urge that voters do the research. But at the end of the day, I think, as everybody knows, unless you're in a courtroom regularly, you're not going to know. And so our view is that the voter does have the right to make this decision to vote no on a judge or a justice. But our belief has long been, and it goes back even before the 2009 election, that voters should have specific knowledge that a judge is not fit to serve anymore. And that could be they're corrupt. It could be they're not showing up for work. They're not doing their job, whatever. But it's not because it's the voter disagrees with one or two rulings. There was a reason why the voters in Iowa in 1962 eliminated politics from the selection of judges. And it seems to me the original intent should be respected today, that we don't want to return to politics in making decisions about whether a judge should be retained.
Thank you, Rox, for that. Continuing on with the Register's editorial, it also noted that it would, in effect, be a futile effort or a futile gesture because Governor Reynolds would simply replace Justice May with another conservative justice. And history shows the 2010 vote did not produce serious threats to the legality of the same-sex marriage decision. Can you explain what you mean by the position the editorial board took that, hey, it's going to be a futile gesture to vote him out for one or two decisions because the governor is just going to appoint another conservative justice?
Right. I mean, that just happens to be, the place we're in. And in 2009, it was a different situation because, you had a different governor, you had a different group of people on the Judicial Nominating Commission, et cetera. But it seems pretty obvious that if voters were to remove Justice May, that they would not get a different result. So I think a lot of people have said, I've heard and read, that they want to send a message. They whether they want to actually remove this justice, or if they had the opportunity, 2 or 3 justices from the court, would they do that? What they want is to send a message. And so the Register in that editorial also pointed out that if people want to send a message on this issue or any issue that's decided by the legislature, your vote is best placed in electing a member of the legislature or a governor, rather than a judge who looks at the work of the legislature.
Yeah, Rox, this is Streit here. The one message that I think we've seen historically through the years is, and it was mentioned earlier by earlier speakers, is that there's a built-in, what we call in Southern Iowa, an againer vote. They're against it. We always had about 20%. It's a little higher now. About 25% of the voters vote no on retention of all the judges, and it's just to keep them honest, so they know there's a check out here. When you build in that standard 20 or 25% in the retention election to vote off a justice or a judge, you only need another 25% to vote off the judge. And what it does is it stacks the election almost to a disadvantage or unfairness when message sending is being you start out with this 20% of the people. What would the paper do to recognize that built-in againer vote, the people vote no?
I'm sure we addressed that many times. I mean, I remember being kind of shocked, quite honestly, to hear colleagues in my own newsroom just sort of, frankly admit, well, I just vote against all judges just to send them a message that, that we're watching. Well, I don't think they're getting the message if everybody votes against them every election. So I think it's a pointless exercise. And, our position over the years, my own position is that voters should vote yes on all of the judges, unless, as I say, they have specific knowledge that one is not fit to serve. And that's a vote, to me, it's a vote of confidence in the independence of the Iowa judiciary.
Do you feel that the plebiscite amongst the lawyers, the opinion of the lawyers themselves, does that have an effect on the general population on what happens during the election or not? I know you always publish it in each district, right, but does it have an effect on the election?
It can. I mean, it was curious that Justice May, that his results were different this time from when he was on the Court of Appeals, which makes no sense. But I do think that a very useful service of the Bar Association survey is to flag a judge who may be a problem. And that has happened a couple of times over the years. And I believe there was a Polk County judge who was voted out as a result because there was some reporting after that plebiscite was published to find out, well, why are these lawyers who are in this judge's courtroom think he should not be retained? And so it's the plebiscite itself may not get you there, but then public awareness that comes about as a result can have the same impact.
Thank you, Rox. Justice Streit, as a former justice of the Iowa Supreme Court, could you explain the process for being nominated and appointed by the governor, this whole merit selection process as compared with the elections in most states? What did you go through, and tell our attendees? I think most are aware of it, but it's going to lead into some more questions. Thank you.
Well, we have what we've always called the Missouri plan, and I've done quite a bit of public speaking down in Missouri, and they just shake their head at why do you call it that? Our plan is nothing like yours. But back in '62, when our Constitution was amended to allow the merit selection process, the Missouri had a plan similar to what we had. Now they've evolved into a political, very partisan process in Missouri on election of judges, just like most of the country is. I was in the minority on merit selection. There's only about 10 states that's an approximation, but there's only about 10 states that have what we consider merit selection, to where we have a committee, and the commission has grown through the years, but it ranged from about 14. Now I think it's up to about 16 members. We don't have a justice now presiding over the nominating commission that we used to have in the past. We thought it was helpful to have at least one judge at the table to tell the half of the commission that we're not lawyers on how things work, or they can't do that and things like that. But the commission is composed of, half of the commission is composed of it's a little more than half of the commission is composed of lay people, that is non-lawyers, appointed by the governor. And the governor will tend to appoint people of like mind and consideration politically. Our particular governor has appointed several lawyers to be a member of that commission, even though it's lay people. And I think they do that because they think when they start to argue behind closed doors on who should get the nomination, they think that the lawyers are fairly effective against the other lawyers that may be arguing the other side. Now, the other half of the commission is composed of lawyers selected according to judicial districts on who should serve as the representative on that commission. There's always an argument that we hear that, well, the lawyers, they're all liberals and they're all going to appoint, they're going to nominate liberal people to be on the bench. And actually, the surveys indicate that there's more Republicans on these nominating commission than there are Democrats. So that's one of those misnomers. But when they get through the commission, they notify the governor of the district court nominees, or at the appellate level, they notify the governor of the candidates that have been nominated for the appeal. And they nominate 3 for the Supreme Court. The Court of Appeals, they nominate 5. It used to be 3, but they've expanded the number. And then the governor has to choose from that group. Theoretically, under our Constitution, if they nominate somebody, neither one of them none of the ones that the governor likes, the governor can sit it out, and then the Chief Justice can make the pick out of the nomination group. But once that process goes on, they have 30 days. The governor has 30 days to make the pick, and then they make the selection. They think it's merit selection because of how the commission works. They are just hard-working individuals. They'll interview people individually at the state level, and at the district court level, it's kind of hit and miss depending on the district. Some districts don't want to have private interviews. Some they just only want to interview them at the commission level. But it goes according to not anything political. It's supposed to be nominated according to who they think will be a good judge, and then the governor makes the pick. So there's going to be politics involved in our process. But it's what in 62 when they formed our merit selection process, they had a sense that this process has to have some accountability to the public. It just cannot be picked. If you go to England and the higher court judges there, it's mysterious even amongst them how they get to be high court judges. There is no accountability in the English court system of the judges. Here, with our state, the accountability we have is that they stand for retention after 1 year or at the next general election, and then they stand for retention election every 8 years for the Supreme Court, and for the Court of Appeals and District Court judges, they stand every 6 years for retention. And we think that's plenty of accountability, and that's why we are talking about that here today. If the issue perhaps today is why are we voting no or why are we voting yes? Many of us think you should vote on their qualifications. Were they doing a good job? Have they had any misconduct in office? Things like that, as opposed to what notable decision that has passed in the past. Now, some people feel that the decision in regards to abortion is so big that'll overpower everything, and that is a sufficient enough reason to vote no on a judicial candidate up for retention if they voted against what they feel is important. But overall, we think that merit selection, the way it evolves, the way it works, that these people will be up for retention, and they should be thumbs up or thumbs down on whether or not they're doing a good job, what we consider a good job, as opposed to having these votes reflect some type of vote on cases that are coming before the justices or the judges. So that's how it's laid out. So every few years, I think we have to bring ourselves to bear what's important in our system, how should it work, and try to keep the public educated on how this works. One thing that the Iowa Supreme Court did after our election, where 3 justices were voted down, is that they decided a big part of the reason is they just know nothing about our court system. The general public doesn't know anything about the judges, who they are, what kind of work they do. So our Supreme Court now goes out at least 4 times a year and holds oral arguments in front of the public in towns throughout the state of Iowa. And the feedback we get from the people it's just absolutely marvelous. They're usually attended full houses, depending on the venue that they pick, and the people just are they just marvel at the kind of institution we have here in the state of Iowa that will sit and listen to these arguments in front of them. And sometimes they try to assign a case that's from that region to be presented to the Supreme Court. A lot of times it's done at night. Sometimes it's done at day. But that's one of the outreaches that the Supreme Court took after the election in 2010. So that's basically the concept of the system that we have for picking our judges and then retaining them.
I would add, Judge, that the proof is in the pudding. If you look at the ratings across the country of the judicial system in Iowa, which has routinely, even by various groups, been rated one of the top 5 in the country in terms of fairness and impartiality. And I think that's a direct result of how judges get to the bench through the merit selection process and then appointed by the governor. And one other thing I would add, in addition to your good comments, is having served on the State Judicial Nominating Commission and been there right where the sausage is being made, My personal experience is the commission members, regardless of their political point of view, whether they're lawyers or lay people, are driven by trying to find the best people to send to the governor, and without regard necessarily to particular political philosophy or anything like that. It's who are the best people, most qualified, and then the politics come in at the governor level. She or he gets to pick among those three that are sent by the commission.
Yeah, it's interesting you brought up that we're a really well-regarded state as to the way we pick our judges. When they survey corporate individuals that are picking places to have their business, and they do this, the Chamber of Commerce runs this survey every few years. One of the reasons I was always in the top 10 or top 5 of the states, if they're going to pick a place to place their business, it is they say our court system is fair. And they will get a fair shake in the court system, as opposed to partisan court systems where politics have gotten the judges their jobs. And we just aren't exposed to it, so we don't understand it. But the judges that are in an appointed, in a elected system, they always have those voters. They run the campaign, and even though we have ethical standards for how they can campaign, they still have that political aspect to their jobs. And the business people that are, if they're making a pick of where they want to establish, one of the top 3 reasons they're picking a particular state is their court system. And that's why, and Iowa scores really high on that criteria.
Great.
If I could add, Bob, that
Yes.
For Justice Not Politics, we, as I've said before, don't tell people how to vote. Our role really is to advocate for fair and impartial courts and to ensure that the merit selection and judicial retention process is remains fair and available and part of the process. And we do think that it does a better job of keeping politics out of the process. But politics is part of every process, and you're never going to fully eliminate politics, but we do think that the merit selection and retention process is key to fair and impartial courts in Iowa. Having said that, we also know that people, as we've said, get to decide on their own. And it is important to remember that when folks vote yes or when folks vote no, they do so based on their own values, based on their own principles. And for Justice Not Politics, there's no judgment in that of how somebody decides. Everybody gets to decide for themselves. And so if there is one case that is so overwhelming to someone that they feel that they have to vote a certain way, that's their right to do that, and we respect that right, and we respect that vote. And we would just ask folks to consider the questions that I talked about before. I won't go through them again, but it is important that we understand that people are voting on their principles, on their values, on how they see the world, and the impact our courts have on them. And so their vote matters, and we would encourage anyone to vote regardless of whether or not they're voting yes or no.
Right. I would say this in rebuttal, however, notwithstanding those good remarks, in this particular case, where there's been considerable focus on Justice May, who's a good judge, who's been served at all 3 levels of the court system, district court, court of appeals, Supreme Court, 3 different nominating commissions have found that he has the merit to be considered, and 2 different governors have put him on the bench. A vote no over one decision, notwithstanding how people might arrive at their decision making, of course, will not change the ruling of the court. And as vigorous as the dissents were in this particular case, none of those justices called for Justice May to be voted out. Reasonable people can disagree and do disagree, in particular on important issues like this. And so while I would never be so arrogant, as I said, to tell people how to vote, I would say that a no vote achieves nothing. It won't change the opinion. In fact, it has a corrosive effect on our system in terms of tearing away at judicial independence and the fear that judges or justices might have that if I work as hard as I can and apply the law as I see it from my perspective and do my job, someone may come after me because I didn't vote the way some poll suggests that I should vote, or the decision doesn't line up with a particular survey of what people think the ruling should be. So I'm sorry to be contrary, but that's a rebuttal to your comments.
No, and I appreciate that and I respect that. And but I just wanted to make sure that we are saying clearly when we say that people have a right to vote and to have whatever criteria, that we mean that. And so there, for us, for Justice Not Politics, we do mean that. And at the same time also working every day to ensure that we have fair and impartial courts and that our system remains strong in Iowa. Because at the end of the day, strong court systems should be about protecting people's rights, should be about protecting the public. And that's an important piece of it as well. But people's vote is their own personal vote. And so we respect if there are differences in that.
Well, to show the irony, what Guy Cook's talking about here is that I was asked to speak to about 250 judges in Kentucky a couple of years ago. And Kentucky's an absolutely partisan state on the election of their judges. They debate whether or not, actually the federal court ordered them to quit doing it that way, whether they put their party affiliation on the ballot for the judicial candidate. And what I learned what did they want me to do? And they really were asking me to tell them how to tone down their partisanship as judges and to remember that they're an independent judiciary. They should not be partisan. And so I had a talk. I wasn't going to change them, but they wanted to have some influence from somebody from a state like ours to talk about trying to keep politics out of their courtroom and even out of electing them. But the irony that I was going to speak to what Guy Cook was saying is that if judges are voted off because of single decisions, the candidates for the judicial offices will self-select, and they themselves will become more partisan. They at some point in time, it's not real common in Iowa that we vote off judges, but if it occurs, it's just a little notch down the road to people forming the opinion that I have to be more partisan. I have to align myself with a political party, a political belief, for me to be a functioning part of the judiciary. They accept a story. And that's the irony of voting off somebody that you think they did an inappropriate decision on one case or two cases, that the next people down the line start filtering themselves. Do I want to join this partisan process? And they self-select and so forth. And I've heard, and the thing I think we're struggling with here in Iowa is that a lot of times you'll ask people, why aren't you applying for a judgeship? And they say, well, I don't want to get involved in all the politics of it. And it's just really hurts when that's their reason. But it has a lot of truth to it. They just don't want to get involved in the politics of judicial selection in a merit selection state. So that's what the people on this panel are, and we're all struggling to try to keep this process out of the political arena.
Well, on that point, I did want to ask, what about the applicant pool? As I understand it, it has gone down significantly of qualified lawyers and judges seeking higher office.
Right, and I think some of that is directly what has been mentioned by the judge, is that a lawyer would go through this process of the lengthy application, the interview with the nominating commission, the selection by the governor, and then they might get voted out. And so is that really a system they want to be part of? I think that's some of it. I think completely unrelated to retention. I think it's the pay level. The legislature, I would say cynically, has tried to punish the judiciary because of maybe decisions they don't like and not raise their salaries appropriately. And then I think there's a perception by a smaller group that maybe they wouldn't get a fair shake when the decision arrives at the governor's desk. But
Guy, let me just, on that point, there's also been some talk that, well, are these Republican appointed justices appointed by the Republican governor, are they just doing her bidding for her? Are you familiar with any decisions by Justice May that in fact were directly against the governor?
Right, and that perception is false, and it's impeached by the evidence. And specifically, Justice May, who some have suggested was selected only so that he would vote as Governor Reynolds wished he vote. He wrote the majority opinion in a case called Bellin versus Reynolds, and found that she had violated what is essentially the Iowa version of the FOIA statute in not producing documents in a timely fashion. So it's, as I said, it's impeached by the actual evidence. Justice May might have a particular point of view and a particular background, but he does his best to rule as he sees it, and in that case, ruled against the governor.
Thank you for that. Just quickly, we're at 2:45. We'll continue. Justice Streit, as a former justice of the Iowa Supreme Court who was not retained following the Varnum gay rights decision, what other lessons did you learn from that outcome?
Well, probably the biggest lesson which I learned before is I think our court system, we were pretty isolated when I was on the Supreme Court. And I think we've learned that we have to reach out to the public to keep them informed, to tell them what we're doing. We have to, I think, even more take a more public stance, which I haven't seen in our court to do yet, but to explain our rulings, or have a public spokesman explain them, or have an advocate from the bar explain decisions, why they went this way or why they did this. Because what was said a little bit earlier here, when they decide a case, and your specific question earlier, Bob, was is that the fix was in on the abortion case, and they were only put on the court for that reason, and that is so far from the truth. It's a legitimate ruling what they made. Now, I personally disagree with it, but it isn't because of any corruption in the political system that happened. So I think to defeat this cynicism that is grown in our electorate right now, and we're a week before one of the most partisan elections that anybody on this webinar has ever experienced. So partisan it is, and we're right down the middle on the support of either side. And then they take that type of analysis and look at the courts, and they think, and that's what we're struggling against. They think that the court system, because of the federal system, the federal Supreme Court, they think that the court system is the same reflection of that we are just part of that politic. And I remember when we, for some reason, we treated it with Rox Laird, when he, the Freedom of Information Council, or what do you call that, Rox?
That's it.
The group. I remember we did a full day of presentation to them on what independent, impartial courts do, and to quit calling us Reynolds judges or Bob Ray judge and this and that, and because we don't make our decision based upon that. Even though back then, this was a program we put on probably 20 years ago, even back then they were starting to see the problem with trying to identify judges with any particular party. And in today, we have to struggle more and more against that. So the lessons I've learned is that we have to always keep working, ask our lawyers to be advocates for the court system, even though they themselves disagree with the cases. I mean, I'm a lawyer now, and I assist on a lot of appeals, and I think Judge Such is a great judge until he decides against me, and that's and some lawyers are more like that than others. But we as a system have to keep reaching out to say we are not part of that politic. That is not part of our system, and we are not just another partisan government institution that's involved in the mix. I don't know what, Rox, do you have any sense of that from the press's point of view?
Well, what I would say is that you're right. What you were discussing earlier about the court taking the show on the road, so to speak, I think I'm maybe unique around the country, and I think it's a great thing. But the other point I would make is that the process of selecting nominees for all Iowa courts is the most open process for hiring public employees anywhere in the state of Iowa. You know, you start with applicants whose applications are made public on day one, and then they submit lengthy applications with examples of their writing and their decisions, and then they're interviewed in a public session, which you could go watch or you can see it on YouTube. And then after the fact, maybe in a session like this, you can go back and look up that YouTube video and see what they said at that time. So, I mean, as an advocate of open government, we just have very little transparency in hiring public officials elsewhere. The courts are unique.
Thank you very much for that. Is there a risk of, if we were to turn, which we're not going to, into a state where judges are thrown off based on public opinion, is there a risk that judges may decide to make rulings looking over their shoulder and which way is the public going instead of on the rule of law? Justice Streit?
That is a risk. I mean, if public opinion becomes part of the process, these are human beings that become judges, and they can't help but to look over their shoulder to see what is the public, take a test of which direction the wind is blowing. That's human nature. And so far, I think we've done pretty well to isolate the judges from doing that, but they're human beings. And if the court system becomes more and more political, then I think they will be testing the winds. They'll have political bosses. Like up in Michigan, they have very partisan elections of judges in Michigan. And I had a friend that was on the Court of Appeals that asked me an opinion. Could you look at this case I'm going to file a dissent in? And I was at a conference where he had it with him and wanted to, and we had met before, and he knew I was going to be there, so he brought it with him. He had me read it, and I just said, "You're going to get in big trouble with this, and it's wrong." And he goes, "Well, that's the system we live in." And I told him not to do it. Well, he opened his dissent by saying the judge from the Labor Party has decided that the law in Michigan is such and such, and I can't understand why the chief judge of the Court of Appeals in Michigan didn't stop that, but it went through, and then he got disciplined and suspended for being partisan in his decision by saying that the decision of the majority on the Court of Appeals decision was a partisan, a political decision that they were making, and he got sanctioned for that. And the courts that have political process, they do all struggle with trying to stay out of politics. It's just harder with their system when they have partisan elections. But if we have, to address your direct question, if we have more and more, if it's more common to challenge judges based on decisions, I think the judges themselves will start, when they accept that as their narrative of their job, they will start looking to see how it's coming. If you ever want to see the worst of it, the worst of the worst is a Miracle on 34th Street. The judge in that case was asked to rule whether or not there's a Santa Claus, and his political boss was telling him, "You gotta say there's a Santa Claus." And the whole movie was about judicial corruption, where he had to finally declare that there indeed was a Santa Claus because of the politics of the decision. But that there's always that threat. And as lawyers, I think we can be careful of not accusing a judge of making a political decision unless you have more clear information in front of you than just you see the ruling and think it's a political decision.
Thank you very much.
Oh, sorry. I think related to that is holding the other two branches of government accountable also for the politicization of the courts. So when the legislature does something that politicizes the courts, like when they added a seat on the nominating commission for the governor, or other things that have happened over the last few years when the governor does something like sit in the front row of the case that was being heard on abortion, and steer down the justices, or other things that she has done outside of the nominating process, even holding them accountable for their actions of putting politics squarely in the courts, and the extremism that we're seeing in our state, whether it is political extremism or religious extremism or such, does impact the courts. And so I think we have to hold those actors accountable in that regard too, because it does impact the perspective of voters and of Iowans, and so I think it's important that we hold those pieces accountable as well.
All right, we're 5 minutes or less right now. A couple of follow-up. So we have 10 questions. Maybe we can get through some of these. What happens if you skip a vote? You don't give it a no or a yes. How is that counted?
It's just 51%, regardless of the number of votes.
So it's not counted yes or no. It's 51% of the counted votes. Got it.
Yeah, or 50 plus 1. I should say it that way. 50 plus 1. 50% plus 1.
The ones that do vote, you have to get 50.
Of people who vote.
Boy, his filter's really going top speed, I can tell.
Holy cow. I apologize to attendees who have submitted all these very good questions, and let's see if we can get through any more of them. Another question, is it not possible judges have already become more partisan and self-selecting? I think going to something that Justice Streit said. Is it not possible judges have already become more partisan and self-selecting? Anybody?
Well, it just mirrors what I just said. I think we have that element going on even today, but that's what we struggle against, that you should not identify. It's nothing more refreshing than I know of a judge that was appointed, and the judge was appointed out of a fairly political battle after the merit selection process. And one of the first rulings that she did went absolutely against the party that picked her and thought she's going to be our champion on this court, and she ruled against them. And it was a refreshing exercise of independence. That no, I'm not your lapdog, and she asserted that authority. But there is always that threat, and we may have that going on even now as we speak.
Thank you, Connie. If a no vote achieves nothing, then why even vote? Why even have the vote?
Why even have the vote? Well, because it's constitutional in the first place, I guess. But I think it's important. One of the other speakers, I think maybe Guy, talked about that it gives accountability to the justices, judges, and it also allows the public to play a role, a direct role. And so it's important for us to have accountability in our judiciary. It's important for folks to be able to have a say, while also having the process of merit selection and nominating. It is, I think somebody else also said this, it is the best process in the nation. And so making sure that we protect it, keeping politics out of it as much as we can, keeping money and influence out of it as much as we can, but also being very aware of what's happening and the influence of that is happening of politics on the judiciary. So Justice Not Politics will keep working at that to make sure that our courts are as fair and impartial as possible.
Thank you. Maybe to Rox or to Guy, I'm newish to the state of Iowa. How can we say that the courts are, quote, fair and impartial, close quote, when the justices are all appointed by a very partisan governor?
Right. Well, it's an appreciation for the system, and that is the governor only gets to select from those that the Judicial Nominating Commission has nominated. And that's where the large measure of politics was removed, and no campaigns. The commission reviews, as Rox talks about, in a very transparent way, those applicants, their detailed submissions, their writings, conducts an interview, it's in public, and then they nominate those they think are the most meritorious for the governor to consider. Of course, at that point, politics are definitely in play. Elections have consequences. And whoever is elected the governor then has the authority, based on being elected, to impose their political point of view by selecting among those three meritorious candidates. And so politics are never removed, but the process for becoming a judge and being considered for appointment is eliminated with the merit selection process.
Thank you. Last question.
Let me just show it. I know you're just running out of time, but I, as a Supreme Court justice, I would swear in people that would come into Iowa on petition, lawyers that came. I had an Indiana lawyer coming in, and he got in on petition, and I swore him in. And of course, you chat after you swear somebody in like that. It's a one-on-one basis. And he says, it's so wonderful to be in Iowa, because back in Indiana, we would not appear in a case if we had supported the opponent to the judge. The judge that was going to handle the case, we could sit or not sit because of the politics of the selection process. And we'd have cases where we tell our client, you will lose if we represent you with this judge, because we supported his opponent. So we will get you a lawyer that supported the judge in his election to the bench. And the lawyer just expressing admiration that coming to practice law in Iowa was so much more refreshing than what he came from in a political system in Indiana.
All right. Thank you. Last question. And maybe I'm going to give this to Guy, unless somebody else wants to jump in. Out of the 1,100 or so Iowa ISBA lawyer members that responded to Justice May, there were 278. Of those 278, the retention percentage is 64.7%. The question from an anonymous attendee is, what about the 35% of ISBA members that don't support his retention? Are they all out for retribution or politically motivated? And again, it's 278 people that responded led to the 64%. So that's 278 lawyers in Iowa, led to 64.7%. Are they all out for retribution or politically motivated? Guy or anyone else?
Right. Well, it's really hard to know, but I think it's important to contrast the results that Justice May had as a district court judge and as a court of appeals judge, where he had a 93% rating on the Court of Appeals and approximately the same number of lawyers who voted. And so either those lawyers have seen something different in Justice May on the Court of Appeals, or their voting is premised upon one or two particular rulings that they disagree with, and as someone said earlier, they wish to send a message. I think if you look holistically at the big picture of Justice May, he has routinely been rated extremely high in all of his positions, and this lower rating, albeit much higher than any political ratings, is probably related to the controversy over this decision.
Thank you. Last 2 points. Judge Hanson, to be clear, in order for a judge to be retained, the judge must get over 50% of the votes cast. If the votes are equally split between retention and not being retained, the judge loses the retention election.
Yeah, true.
Yeah, so that's the 50% plus one, right?
All right.
Yeah.
And then lastly, we
Yeah.
had a question. Why aren't we hearing from Mel Shaw, the president of the Iowa State Bar Association? And the answer is he introduced all the panelists, and that was his only role in the process. Thank you again, Mel, President Mel Shaw, and everyone else on the panel for your hard work today. And thank you, attendees, for participating. I think we had, I can't remember the number. What did we have? 300, something like that. And we will strive to get 1 hour's worth of CLE credit, and we'll let you know if you get it. Anything else for the good of the cause?
I would direct folks to President Mel's comments in the Iowa Lawyer about judicial independence. Very well written in a previous Iowa Lawyer president's letter.
Fantastic. Thanks, Guy, for pointing that out.
Thank you. Just one thing, if I could, just Bob, just very quickly, I want to say that the Iowa State Bar Association position is to support an independent judiciary in this state. There's no question about it. I think overwhelmingly the judicial performance evaluation indicates that a great number of our district court judges got 84% or higher. There were a few who received 100% rating. Most all of our judges are doing excellent work, and there are some criticisms of some, but I do stand with the panel here that voting no largely won't result in much. But the legislative action really is a key to changing the things that we do not like. And I just want to also say in closing, I do strongly support the dissent of Justice Christensen. I think it was a marvelously written dissent, but voting no is a person's independent decision, and hopefully everyone received beneficial information from today's program.